Hello again, my fellow emoluments. My name is Christopher Howland. I am CEO of eClause LLC. And if you're watching this video, you have been instructed to do so for training purposes. Today's topic we are going to discuss is tort claims, as you can see on the slide here. Purpose of this presentation is to acquaint you with things like post-sentencing investigations. As you're going to be undoubtedly investigating some type of fraud or bad faith based on what's been going on in the current political spectrum. So the source materials for this presentation are here on the screen for you, and they will be pictured in each slide where they are applicable. So to better comprehend how to discharge any fraud, known theft, or other such bad business practices, you must first be able to grasp the full scope of what impeachment actually does in context of any case, transaction, or series of transactions, as in these cases. And you're going to end up having to do this with the full awareness that everything you do is going to be conducted with scrupulous attention. So this type of a job is it's going to be taxing on you. So let's start with what a tort is as it's defined in the dictionary. Usually when people are given a job, a task, a word, first place they go is the dictionary. So why shouldn't you? So a tort is a civil wrong or other breach of contract for which a remedy may be obtained, usually in the form of damages, a breach of duty that the law imposes on persons who stand in a particular relation to one another. Those of us in position of emoluments, we are, of course, amenable to the people. Tortious conduct is typically one of four types: a culpable or intentional act resulting in harm, an act involving culpable and unlawful conduct causing unintentional harm. Number three is a culpable act of inadvertence involving an unreasonable risk of harm. And of course, number four, a non-culpable act resulting in accidental harm for which, because of the hazards involved, the law imposes strict or absolute liability despite the absence of fault. The branch of law dealing with such wrongs is, of course, usually people would go to the judicial branch. However, as the law dictates, we know we take our claims to the legislature, right? So that's where you come in. Tort claims, okay, the federal or the Congress enacted what's called the Tort Claims Act. This would be articulated in the form of a federal or state statute that, under stated circumstances, waives sovereign immunity and allows lawsuits by people who claim they have been injured by the government or its agents and employees. These laws typically require the prospective plaintiff to file a claim before starting litigation, giving the government an opportunity to engage in discovery and sometimes settle. Although often called Tort Claims Act, these laws often apply to contract claims as well. This is where we're going to start getting into some of the transactions, which I'm going to cover in a different video. But for the purposes of what we're doing, we're looking at tort reform. Okay, so this is a movement to reduce the amount of tort litigation, usually involving legislation that restricts tort remedies or that caps damages and awards. especially for punitive damages. Punitive damages are obviously almost always prosecuted. So advocates for tort reform argue that it lowers insurance and healthcare costs and prevents windfalls, while opponents contend that it denies plaintiffs the recovery they deserved for their injuries. This argument literally stems from the maxim of law: the person of a human being can have no price put on it. So, as you can see, typical political questions must be given a first in the affirmative and then in the negative. So what you're going to be doing is you're going to be proceeding or constructing what's called a writ of supervisory control. Now, in so much as transactions, occurrences, and events, okay, transactions is probably going to be where you're headed. This is a writ issued to correct an erroneous ruling made by a lower court, either when there is no right to appeal or when an appeal cannot provide adequate relief, and the ruling will result in gross injustice. So this, of course, can be found on page 1849 of Black's Law 10th edition. As with any other process, in constructing your writ, you're going to need rules of evidence. For example, who is under the scope, right? Scope and authority. And, whom are you going to be investigating and why? As you see, according to federal rules, public office includes a public agency. You're going to be hearing a lot from the constituency that many of these government offices are crime scenes now, and that's not far from the truth. So, when you think of terms of a bureaucrat, this is what the Merriam-Webster's thesaurus actually says about bureaucrats. So, a worker in a government agency. And of course, this being Merriam-Webster's is usually the source that you'd find on your bookshelf at home. The example here is actually pretty hilarious when you think about it. Bureaucrats at town hall seem to think we need a permit to build a tree house. I mean, come on. So anyway, synonyms for bureaucrats are functionary or public servant. Okay. So when you are on the clock, you are a public servant. And if you're not functionary, then you won't be on the clock very long. Related words, right? These are related. These are things like clerks, office holders, officials of really any kind, employee or underlying or some other type of worker. Now, it's just going to depend on what the scope of your job description is. For example, somebody pushing a broom is not going to have the same authority as an official or even a clerk for that matter. So again, there's going to be some hand holding involved in this, especially with the lack of even so much as a basic civics education over the last 20 years. So your patience is going to be tested, believe it. So we're going to be looking at relevance and its limits. So again, we're going to quote rules 401, 402, and 403. To proceed as what we would believe to be relevant to include in your tort claim or your writ of supervisory control. Excuse me, which will ultimately lead to a discharge, which we'll cover at the end here. So just to kind of stick to the format, let's continue with the test. There's a test for relevant evidence under 401, general admissibility of relevant evidence under 402, and of course there's exclusions under 403, which would be excluding relevant evidence for prejudice, confusion, waste of time, or other reasons. You're going to deal with plenty of bar members who are going to beat you to death with the exclusionary rule, which is not actually 403. It's another form of legal doctrine. But you can expect that if you're going to make a statement in your writ, you better have something in the appendix that backs it up. Short version, easy to handle. So in so much as the evidentiary standard, depending on where you are, which pillar of law, right? Executive, legislative, judicial. In the legislative, we're going to be this person, the solicitor or the presenter, right? Typically called in oversight hearings a witness. So you're there to provide oversight and answer any questions that the committees may have for you. You're going to give things like impact assessments, like pretty much exactly what this test does, right? This test was constructed to deal with positives and negatives, right? This is something we use in the private sector. So what we're looking at in the evidentiary standards is preponderance of the evidence and beyond reasonable doubt. In this republic, those are the only two. You're going to hear this clear and convincing garbage. That is a jurisdiction foreign to our form of government and unacknowledged by our Constitution, as you see in Quadrant 4. The fact that this goes all the way back to the riddle quoted in Quadrant 3 as articulated in the Declaration of Independence. So now we know what these foreign emoluments were doing while we were on the clock building the country all day long. So now that you can clearly define which evidentiary standard, right, beginning with preponderance of the evidence, right? Depending on that preponderance, we're going to figure out, does it rise to the level of beyond criminality, beyond reasonable doubt? Attorney General Barr has done many a presentation on this. I refer you to his direction for further clarification. A lot of these things are going to come to you by way of what's called a parliamentary inquiry or some other form, request for some other form of information. Having written, few parliamentary inquiries in my day, when I began to ask the question of what kind of emolument is that, it wasn't just specifically any particular advantage, profit, gain, or benefit. It was, as I've shown in the litmus test here, what color of law is it you're attempting to enforce, right? Because they're, in so much as our republic, right, we have advantage, profit, and gain, and we support that through the market, margin, and capital. So that's the actual republic. So, and the market, margin, and capital came post-Reconstruction, 1871. So jurisdiction of this office is 28 U.S.C. 1443, where we go in and we audit what happened in either a specific case, a specific transaction, or set of transactions. So depending on the inquiry, and did it come from a constituent, or did it come from the request for information come from a potential court clerk requested by somebody who was sentenced, which we're going to go over here. So what you're going to start doing is you're going to start gathering your information, bring forth the adverbs, right? Why, how, where, when, and to what degree, right? Adverbs should not be used to modify nouns. So this is kind of going to be where you're going to start. With this lawful principle in mind, the will and the purpose distinguish the crimes. So again, you're going to have to look at some of these things with a set of fresh eyes, which is not going to be easy for you to do. A lot of these things, because we're talking about transactions, you're going to start to see a lot of business torts. These are torts that impair some aspect of an economic interest or business relationship, causing an economic loss rather than property damage or bodily harm. Business torts include tortious interference with contractual relations, tortious interference with prospective advantage, unfair business practices, misappropriation of trade secrets, usually corporate espionage is the way we refer to it in the private sector, and product disparagement. So pay attention to things like wrap-up smears, negative ads, calls for boycotts, that kind of typical stuff that we can read through Annals of America and laugh at these people all day long. And believe me, you will. This job sounds like it's a pain in the butt, but it's actually pretty fun when you figure out exactly who's doing what to who. So constitutional tort, this is where discharge comes in, right? Anything in conflict with the laws of a state or the Constitution is notwithstanding. It's even in the books. So this would be a violation of one's constitutional rights by government officer, redressable by a civil action filed directly against the officer. Now you're going to start hearing a bunch of bar members running around screaming and yelling, there's no such thing as a constitutional right. Well, then why can I go and find it in the dictionary? So, now that we, as I said, we can clearly comprehend, right, where Title 42 came in. This was the last attempt to right the ship by Congress when they wrote Title 42, right? This was supposed to be a mechanism for the constituency to use in federal courts. As we're finding out now, the federal courts have been dismissing these cases for failure to state a claim. And the law dictates they are to redress their grievances with the legislature first. So once they redress them, you're going to be getting what's called a referral, right? Referral for investigation. So you're going to report not only back to the court, you're also going to report back to the committee. So you can expect to rise and report frequently. So your constituent or the person who has the interest in this resolution is proceeding from this legal principle more than likely. We should follow our own rather than a foreign law. So just kind of help you get your mindset. Okay, you're going to see I use maxims of law to articulate the many conversations that I've had in both doing the show and just working with clients, general, whether it be in this capacity or whether it was on the clock working for a big company. So in many boardroom meetings, dubious expressions are obviously construed against the person using them. You'd hear things like, why are you even asking such a stupid question, and that kind of stuff. So dignitary torts, these are torts involving injury to one's reputation or honor, right? Declaration of independence, right? To our future, do we secure our sacred honor? So in the few jurisdictions in which courts use the phrase dignitary tort, such as Maine, defamation is commonly cited as an example. So also erroneously termed dignitary tort. So this is usually libel if it's in print, slander if it's spoken. So, but if you've progressed long enough to get to this video, you're getting into the technical terminology. You know the difference between libel and slander by now. So we already went through business torts. Let's look at an environmental tort. You're going to start hearing some of this stuff, particularly from the climate change folks. So without going into too much of these, what you can do about Mother Nature. Well, again, I'll just say, like I always say, go ask my mom. So let's look at a government tort. This is a tort committed by the government through an employee, agent, or instrumentality under its control. What we're talking about here is unlawful uses of the Commerce Clause. These documents that are being used against the person who may be incarcerated or not, it's all made up, right? This is something they wrote. Don't ask me how they pulled this crap off. But it is what it is. So we have to go in there and unscrew it. So welcome to loss prevention. This is the tort may or may not be actionable, depending on whether the government is entitled to sovereign immunity. Well, again, many court cases have said, and you can expect it coming down from the Supreme Court that there is no such thing as immunity. Nice try, right? The only thing you can be immune for is if you're in performance, discharging the duties of your office, such as investigating injury by fellow servant claims, right? And other such type, claims. So the person has the advantage should also have the disadvantage. This is the essence of reciprocity, because reciprocity is defined as the second definition being a mutual concession of advantages. So keep your mind in that my intent gives a name to my act. In my case, it was loss prevention. So, you're going to get into mens rea, right? Malum in se, malum prohibitum. Those are your lawful principles from which you're going to proceed, right? Was the mind guilty or not, right? Because now you're having to prove intent. So intent gets into intrinsic fraud. I try to stay in the extrinsic side because that's stuff I can stick in a document and go, yep, you can verify that. Much more expedient. So this is a tort committed by someone acting with general or specific intent. Examples include battery, false imprisonment, and trespass to land. So also termed willful tort, or of course negligence or gross negligence. So marital torts, these are, I think, going to go by the wayside. I've referenced them here just because there are a few jurisdictions that do recognize them, but most are getting back to the common law, which is husband and wife immunity, right? That's privileged communication. It falls under the rules of privileged. Don't touch me there, right? Why? Because insanity prevents marriage from being contracted because consent is needed. I don't recall ever going to a wedding or ceremony to where God said yes or no. Usually it was speak now or forever hold your peace, but I move on. Not to be confused with maritime tort, which is usually admiralty jurisdiction or contracts. And when I get into contracts and transactions, units of measure, you'll understand exactly what I'm talking about there. A mass tort. This is a civil wrong that injures many people, right? Examples include toxic emissions from a factory, the crash of a commercial airliner, and of course, containment from an industrial waste disposal site. There's also foreign emoluments, which have no definition in the dictionary. Again, you want to go into the biblical side of this. Those of you who would argue the religious side of it would tell you the in quotation of scripture would be the greatest feat the devil ever accomplished was to convince the world he didn't exist. Well, how would you do that? You would create a word, emoluments, and selectively hide it, right? In order to hide it in plain sight, which is pretty much exactly what's happened over about the last 30, 40, 50, 60 years. So, the crime of plundering or looting is slavish. Innocence alone is free. Negligent tort. This could be a rabbit hole. Watch yourself. Be careful because you're going to be getting into, conduct, negligent or gross negligent conduct, right? So, pay very close attention to this definition because this definition is going to help you transition between negligence, gross negligence, and of course, fraud and deceit. So this is a tort committed by failure to observe the standard of care required by law, by law under the circumstances. So deceit and fraud, as you see these two principles here. Corruption, deceit, and fraud always benefit the actor in government or, of course, the corrupt idiot who is the reason you're watching this video. So you can thank them. A personal tort. This is a tort involving or consisting in an injury to one's person, reputation, or feelings, as distinguished from an injury or damage to real or personal property. So, factor out feelings. I'm going to tell you right now, just trust me on this. Nobody cares about anybody's feelings. Moving on. Fraud is presumed against one engaged in an illegal act or transaction. Know it, understand it. This is why you're here. Transactions between others can benefit, but should not injure anyone who is not party to them. That's why these pretended acts of legislation that we are now auditing, right, these bills of attainder created by these foreign emoluments called bar members. So I said get used to having to clean up other people's garbage, because that's where you're headed. There's a preconception tort. This is a tort that is committed before the victim has been conceived. Talk to the moms in the family rights movement about that. Prenatal tort. This is a tort committed against a fetus, right? And again, for this particular side, I would just proceed under this. The law knows neither father nor mother, only the truth. Stick to the truth. It is what it is. Primophasia. Primophasia is an unjust or intentional infliction of harm on another person, resulting in damages by one or more acts that would otherwise be lawful. This is what we run into a lot with licensed professionals, specifically with disclosure requirements. Something is not disclosed to you by, especially we saw this a lot in real estate transactions. When a seller, you take a listing, and when a seller doesn't disclose to you what's called a non-latent defect, which means that something that you can't see. So, it's when you're getting into real property transactions, get to know some contractors. So they'll be able to show you ways and things to look for, how to spot non-latent defects through an expert's eye. So property torts and public torts. Property torts are pretty self-explanatory. Public torts are just a minor breach in law, what would be normally termed as a misdemeanor. So this is where I got into when I was talking about malum prohibitum and malum in se, right? So we're getting into those public offices, those public officers. So this is a minor breach of the law, such as a parking violation, that although it carries a criminal punishment, is considered a civil offense rather than a criminal one, because it is merely a prohibited act, right? Not an inherently reprehensible conduct. So now you can put into context malum prohibitum and malum in se. Quasi-tort. This is a wrong for which a non-perpetrator is held responsible, a tort for which one who did not directly commit and can nonetheless be found liable, as when an employer is held liable for a tort committed by an employee. You're going to find out that there's going to be a ton of bar members who are sitting on these code commissions rating this garbage while we were at work all day long, who are going to be held responsible. Know it, comprehend it, and be prepared to do get out your magnifying glasses, because you're going to be having to find these guys. So we know that a special law detracts from the general law. Again, you're going to start to see the pattern that these legal maxims that are at the bottom of the screen, I put them there because, as I said earlier in the video, this is the logic and reasoning from which the claim originated, the thought process of the person who was injured. So sanctions torts, toxic torts, these are of course arising from some form of toxic substance. Do yourself a favor, make sure you have the appropriate professionals dealing with toxic substances, whatever those might be. So your sanctions tort, this is a means by which to recover for another party's discovery abuse, whereby the judge orders the abusive party to pay a fine to the injured party for the discovery violation. This is not a tort in the traditional sense, but rather a form of punishment that results in monetary gain for the injured party. Again, this is I put in here the definition from a right to a cause of action. I apologize, I didn't include the picture of Black's Law Dictionary, but that's the source material. And this is the definition again. The predication, right, for your writ of supervisory control or replevin or whatever other document your work product is going to yield pursuant to your investigation. So this is the right to bring a specific court case. And number two, a right can be enforced by legal action, right? A chosen in it, or yeah, I'm sorry, I think that should be a choice in action. But again, I pulled it out of the dictionary and typed it just as it was written. Private right of action. This is an individual's right to sue in a personal capacity to enforce a legal claim. So if you want to go further into that, you can, of course, refer to presumption against implied right of action. So again, that was usually going to be what the defense bar member is going to try to throw at you. Tort damages, tort feasors. Tort feasors are the actors. You're going to probably get orders for investigations. And if people are paying attention to the show, I am hoping that they are going to list those persons as interested parties. Why interested parties as opposed to bad actors? Interested parties, right? Again, there's been no allegation of a crime made. For all we know, this interested party is just somebody who was in a position of emolument on the clock, and a document may have run across their desk, and whether they even realize it or not, they have something relevant to add to the case. But a tortfeasor, okay, this is where you're going to start to make your clear distinction between an interested party and an actor. So a tortfeasor is someone who commits a tort or a wrongdoer, a bad actor. So two or more tortfeasors, which are concurrent, whose simultaneous action cause injury to a third party. Pretty close to the definition of corruption, wouldn't you think? Such tortfeasors are jointly and severally liable. Consecutive tortfeasors, this is two or more tortfeasors whose actions, while occurring at different times, combine to cause a single injury to a third party. This is where we start getting into compartmentalization. So consecutive tortfeasors, good luck trying to find any judge who's going to allow prosecution for somebody who was sitting there doing a job, getting paid to do a job, and they had no idea that that job was leading to another job, which was causing injury. So joint tortfeasors and successive tortfeasors. These are two that you might want to pay particular attention to, especially when you're talking about crafty government actors, right? Some of these people they're not stupid. They didn't get to the positions they got to by being stupid. So you're going to have to pay very close attention to the conduct of the person, right? You know what, if you're watching this, you know what the signs are. So I won't go into the anything much other than a person acts contrary to the law who does what the law prohibits. Person acts in fraud of the law who, without violating the wording, circumvents the intention, right? So there's your principle from which to proceed. So rulings on evidence, right? Always refer back to your rule books. These are the 2020 sources, by the way. You want to preserve a claim of error, right? And of course, not needing to renew an objection or offer of proof. Why? Because if you're doing these correctly, you've already assembled your appendix, and your document, your writ of supervisory control, will narrate the information in the appendix and why, what is, where it is. So this is effective. This is going to be determining how effective your work product actually is. So beware of things like fragments. I mean, it is what it is. Tortious interference with a business advantage, denial of benefits, conduct, battery, Tortious Act, that type of stuff. So tortious interference with contractual relations. This is, again, going back to transactions, which I'm going to go into great detail here shortly. Not in this presentation, in another one. A third party's intentional inducement of a contracting party to break a contract, causing damage to the relationship between the contracting parties, also termed unlawful interference with contractual relations, interference with a contractual relationship, interference with a contract, inducement of breach of contract, and of course, procurement of breach of contract. So everything that is italicized there, you can bet you're going to hear that out of the bar members. So in so much as a rule of contracts, just follow this principle, always in doubtful cases, which is that is to be done by which a bona fide contract may be the safest condition, except when it has been drawn up clearly contrary to the law. So tortious interference with economic relations, tortious interference with prospective advantage. Again, knowing and understanding the essence of reciprocity, right? Which is the mutual concession of advantages. Again, here is that legal principle. I put this slide back in here again because I wanted to make sure that what we're talking about is the difference between slander, libel, and where that would come in relationship to a contract. Because you're going to get into liability, not covered under this particular presentation, because that would get into what's called a writ of deceit. You may participate down the road in doing some of these. I've done a couple myself, and I can tell you this is actually a fairly simple document. This is a writ against one who deceives and damages another by acting in the other's name, right? This is also, I go under this, tort of another doctrine. In some states, a statutory rule that authorizes a court to award litigation relating to expenses, including attorney's fees, to a prevailing party forced to bring or defend a lawsuit against a third party for a tort committed by someone else who refused, after notice, to bring or defend the lawsuit. So, again, recapping here, we have to make sure that we are mindful of these public offices. Like I said, these agencies, right? We're not talking about police officers and sheriffs. We're talking about agency actors. And there's a clear distinction there. But the public's perception of that, they see a uniform and they think of public agency. No, public agency is somebody who's getting paid a stipend, right? Just maybe like law enforcement or sheriffs get paid a stipend. But this is not somebody with police powers, which is why they have to have a police officer escort them. So, applicability of the rules. Court, where judges and courts apply, cases and proceedings apply, and of course, rules on privilege. Be very careful. One of the things that you're going to be, you want to make sure that is going to help you, believe it or not, constructing your supervisory control is exactly how many times the actors stepped over somebody's privileged communications or privileged relationships, whatever those might be, parent, child, husband, wife, et cetera, et cetera, et cetera. So even as exceptions, the rules of privilege don't even fall under the exceptions. Privilege is the exception to the exceptions. So double negative there. We're going to start getting into the conviction procedures. We pretty much already know what this is. So whether the the convicted party knows and understands their right to appeal when they're requested to appeal, right? Appealing a conviction. If the defendant pleaded not guilty, right, and was convicted after sentencing, the court must advise the defendant of the right to appeal the conviction. Appealing a sentence after sentencing, regardless of the defendant's plea, the court must advise the defendant of any right to appeal the sentence. So, again, are we appealing the sentence? Are we appealing the conviction? Because those two things, believe it or not, are going to be connected in your work. Know it, understand it. Because in so much as the people, and as far as I'm concerned, I agree with it, truth is the mother of justice. So this is where we're going to be starting to come in. Remember those referrals I was talking about? This is where I'm going to start getting into this stuff. If the defendant so requests, the clerk must immediately prepare and file a notice of appeal on the defendant's behalf. Now, this is going to obviously, by default, goes to the appellate court. These requests should also be directed to the DOJ to commence an integrity of process audit. Things we're going to be looking for are Brady and other such emoluments violations of subject matter to be audited. So, again, paying attention that we're going to be talking primarily about transactions. So, the circumstances of those transactions, well, you'll see it as it goes along. Here's the process as it's laid out in Mason's, right? The right of a legislative body to make investigations, right? So the right to appeal in the legislature is absolute unless you have no political right or authority in standing. Again, by now, I think enough people have picked up on this that if you've gotten a referral from their case, they're smart enough to know what a post-sentence investigation request is. So these are common to those of us who know they exist. Requesting one be done on your behalf, pending motion to expunge, which is a motion 39. The conviction upon verification of your claims can also be handled and discharged in any of the three branches at any time. So in so much as being found, guilty by a jury of your peers, we would certainly hope that the third pillar would assist with, righting any wrongs, which is the intended purpose of the appellate court. So I have yet to run into an appellate judge who doesn't do that job. So anyway, moving on. So let's get into those writs of supervisory control and the definition. You're going to hear bar members jumping up and down and yelling and screaming, "Oh, you can't do that. You can't do that." Want to bet? Somebody has reached out to their legislator and said, "I want this investigation done." The legislator can, under principle number 10 here, an investigation into the management of the various institutions of the state and the departments of the state government is at all times a legitimate function of the legislature. So as you prepare your reporting, right, your writ or whatever other reporting you're going to be providing, right, you're going to be sending copies to all three branches, including the origin or originator of your investigation request or order, whatever we're going to call it. I don't know. Again, get to know the Mason's Manual. This is the best advice I could give you. And also get to know Jefferson's. So, for example, on Mason's page 17, section 7, numbers 1 and 2. Constitutional provisions stand on a higher plane than statutes and are mandatory. Bar members don't care, and certainly the other foreign emoluments don't care. The people, they care. You better care. So, if a Congress or state legislature violates a constitutional requirement, the court will declare its enactment void. So again, the only way that the court can do that is if you present a discharge to the court. So could be in the form of a recaption. If you've entered a writ of replevin, a writ of recaption, this is a writ allowing a plaintiff to recover goods and damages from a defendant who makes a second distress while a replevin action for previous distress is pending. So, as many times as they're going to try to, they're only going to make life worse for themselves. Let's just put it this way, because, it is what it is. So, submission on a point of order. This is a process you need to know, because this is going to be how the committee's going to work. The person of a human being can have no price put on it, period. End of discussion. So number one, a point of order is decided by the presiding officer without debate unless, in doubtful cases, the presiding officer submits the question to the body for advice or decision. A lot of times we're going to get orders from a court, whatever. We're going to be having to rise and report post-investigation, post-sentencing, post-conviction, post-whatever. So we're going to be predicating based on whatever that order is, right? So it's upside down, but you'll get used to it once you've done it a few times. Section 459, right? This would be a motion to reconsider. So, for example, if a previous legislative body or Congress enacted something that needs to be repealed, okay, that would be under a motion to reconsider. So when the two houses are meeting in a joint session, they have the right, as long as they are in session, to reconsider any question they have had before them or any vote they have taken. So we're going to be looking a lot at these repugnant acts that somehow weaseled their way into the process here. Here's the law. There's your constitutional provisions and those foreign powers, foreign emoluments, right? Foreign states, things foreign to the people, period. And this is those bar members, fourth and fifth pillar actors who are claiming exercising powers they don't have. First principle of group decision making. Article 1, Section 10, Clause 1, no state shall enter into any treaty, alliance, or confederation, grant letters of marque and reprisal, coin money, emit bills of credit, and, make anything but gold and silver coin a tender in payment for a payment of debts. This is where we're getting into bills of attainder, ex post facto law, or law impairing the obligation of a contract, or grant any title of nobility. It is what it is. Law speaks to all with one mouth and one mouth only. So, as you notice, I put no in big bold print here. So I say there's one side of this political spectrum that just don't comprehend what the word no means. So, Jeffersons, you're going to be presenting petitions. Your constituent is going to be constructing remonstrance or remonstrance, depending on how they wish to pronounce it. Anybody who's read one of my reports would probably use the latter 1,472 pages. Sorry, that's my bad. Anyway, page 294, section 443, number 3. Legislative body can ratify only such actions, its officers or committees or delegates, as it had the right to authorize in advance. It cannot ratify or make anything valid, right? Make valid anything done in violation of the Constitution. So if we can go into it, for example, and you see somebody interfering in commerce and somebody's right to work, well, there's cause to go in there. And, that seems like a simple, even, ridiculous way to articulate that, but sometimes you just have to be that simple and that ridiculous, now that I know and understand that the elements that I'm dealing with, and you'll get it as you go. Page 353, 517, number 1, right? This is going to be primarily for the use of the internal board members, right? They may or may not know this. I include this information in the document. So they can go, number 1, go to that I want to get them as acquainted with the book as I am, and as I hope you will be by the time you've learned how to do this. You'll be able to recite this book from cover to cover. Impeachment, right? I'm not going to read through the whole thing, but this is the process of impeachment, okay? And this is going to be what you're doing, technically speaking. You are impeaching what has been presented to you. So there's a document referred to as the Treatise on Federal Impeachments. This kind of gets into the history, right? House of Lords and the House of Commons and that type of thing, dating back to Old English law. But the kind of gives you an idea of the process, right? The accusation, right? What work product is and where it comes from. Because this is going to be where you're going to proceed, right? Your work product means the protection that applicable law provides for tangible materials or its intangible equivalent prepared in anticipation of litigation for trial. That could also be appeal. So be prepared to articulate clearly and concisely any special exercise of rules or provisions of law as shown in the following slide, where the use of color of law clearly demonstrates just cause as to why this particular case fails, and why the courts found continued litigations to be a moot point. From this declaration, the known theft attainder can be discharged. So here's the example. The blue and red indicate on the clock, off the clock. So the fact that the communication is between husband and wife is protected under privilege, this department, this emolument, fake emolument, foreign emolument, has no standing to act on behalf of, right, and interfere in that relationship, whether it's good, bad, ugly, indifferent. You don't have that power, period. So that's why I said these are, especially when you get into some of these quote unquote domestic violence contracts. Don't get me started, but you'll pick it up as you go. Exoneration. This is going to be often the end result, right? It is what it is. And the court must exonerate the surety and release any bail when a bond condition has been satisfied, or when the court has set aside or remitted the forfeiture. The court must exonerate the surety who deposits cash in the amount of the bond or timely surrenders the defendant into custody. And in these cases, we will have already pretty much done the majority of that. So these provisions exist in the legislative litigation as well. Motion number 6 to appeal, motion 39 to expunge, and a motion number 40 to enter when no other provision are made by existing rules. Criminal procedure, rule number 47. This is general, a party applying to the court for an order must do so by motion. Same thing goes in the legislature. Whatever your document is, it must be supported by a motion. So you're probably going to use motions number 40 and 39 most often. Unless, of course, we get to a point where they just want us to use a number 24, which is just a general motion. Form and content of a motion. I mean, here it is. So again, there's your list: 6, 39, and 40. Those incarcerated, we're going to be probably using the habeas corpus process quite a bit. Timing of a motion, and of course, affidavit supporting a motion, right? Clear, concise statements of facts. So, again, fairly simple process, not a lot to it. Rule 609, impeachment by evidence of a criminal conviction. This is going to be what you are doing. Remember, I talked about that. So here's the rules of evidence that go along with Jefferson's manual, right? In so much as how to assemble evidence for an impeachment, right? Are you impeaching the case, right? What are you investigating, and how and why did you get in investigating it? Impeachment by evidence of criminal conviction, right? And this is where we're going to get into technical violations, or more than a mere technical violation, where we can literally prove somebody lied, for example. Don't fall out of your chair laughing. It actually took the bar member 17 years in the case cited, Hardwick versus Orange County and Vreeken, to decide they can't lie and present false evidence in court. So you can imagine that the folks that you're going to be working with are a little more than slightly miffed. So this is really the substantive nature of why I assembled this particular slide. So the following rules apply to attacking a witness's character for truthfulness by evidence of a criminal conviction. Do yourself a favor, avoid this, because now you're getting into libel and slander yourself. What you believe and what you can prove is two different things. Because, again, avoid the mudslinging. There's been enough of that going on. Because what you're going to ultimately end up doing is these bills of attainder and the multiple bonds and various other fake money transfer documents, whatever those are, you're going to find those in what's called a SAR, Suspicious Activity Report, submitted usually by financial institutions, tellers, and bank managers, and that kind of thing. That will pretty much outline what the activity was that raised their red flag, that made them fill out the SAR paperwork and submit it. So again, you're going to find a lot of SARs that are going to fit in context with your bill of lading. So this is just an example photograph. Yours are going to be spreadsheets that are going to be probably hundreds of pages, or I'm sorry, hundreds of lines long. So the negative nexus mechanism in the private sector, this was a system we used to discharge known theft, not to, and again, that's why I said, you'll get it as you go along. So here's what that discharge looks like, comes from American jurisprudence. And this is basically pleadings in practice. Discharge comes by and through the following diction attached to writs of replevin and, of course, supervisory control. Of course, that said statute is illegal, unconstitutional, and void in that it purports to grant the defendant an irrevocable or uncontrollable grant of special, there it is, emoluments, privileges, or immunities contrary to and whatever the applicable section of law, federal law, and of course, whatever state law that corresponds with federal law. Do yourself a favor, incorporate both. The book only requires state law, but remember, there's supreme law of the land, minimum due process. There are those who are going to argue the supremacy clause with you till the cows come home. Who cares? If you can satisfy both supreme law of the land, minimum due process, and then, of course, any protections that rise above that minimum process that are articulated in the state constitution, it only strengthens your discharge. So, again, actors aren't gonna, they're gonna give you all kind of crap for doing this, but you know what? The stronger your document, the stronger your discharge, the stronger standing you have in law to do your job. So, thank you for watching. Hope you found this content helpful. And even if it was only for review purposes. So on that, I'm going to end this particular presentation, and hope you enjoyed it.